Have you ever had that sinking feeling at the airport? Passport in hand, everything packed, and you're still not sure if you'll be able to be back into the US. Or maybe you have heard stories from your friends stuck abroad during visa stamping, sent to secondary inspection, or even being questioned for something that happened years ago. Well, guys, you're not imagining it. Travel is getting riskier for green card holders and for visa holders alike. We are going to talk more about that. But before I talk about that, let me read out this important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, so guys, as I was talking about that today, we are going to talk about how travel is becoming difficult for green card holders and other visa holders alike. And also, I mean, most importantly, green card holders and H-1B visa holders. So, what's happening? Why is it happening? And how can you be prepared for that? We will be covering all that in today's show. And today, we are joined by someone who truly gets what's going behind the scenes. Steven Hamrick, a seasoned immigration attorney from Trow and Rahal. Steve's not only helped countless professionals and families through tricky visa issues, he actually spent over 2 decades working as a immigration attorney. Well, he's sharp, he's strategic, and most importantly, he knows how to explain things, which we love doing on this show. So, without any further ado, let's welcome Steven Hamrick on Immigration Talk Show.
Rajni, it's so wonderful to be with you again and all of my friends here at Immigration Talk Show.
It's wonderful having you, Steve. Thank you so much for being here. Thank you so much for taking out time and saying yes to doing a show on such an important topic. And you have been continuously posting a lot about this topic on your LinkedIn. So we have been also tracking your LinkedIn and your post too. So we'll get into that. We'll talk about more about that. But before I do that, I would like to welcome our audience. Guys, we are live on YouTube, LinkedIn, Facebook, X, and also on Instagram. So make sure you like, share, and subscribe this channel, Immigration Talk Show, for more immigration related shows and immigration related news. And yes, don't forget to subscribe to us. We are Immigration Talk Show. And now, if you have any question related to travel issues going on, and if you're traveling or if you're coming back to the US, and you have any questions that you would like to ask the attorney, you would like to ask from the attorney, make sure to comment in the comment question. Put your question in the comment section, and you can also join us on call on the number 425-436-6335. You can put the access code, which is 988888. Yes, we will. Take your calls. We'll ask your questions that you put in the comment sections. I think, okay, Rag is already here. Rag says, hello, Steve and Rajni. Hi, Rag. I
Hi,
hope
Raj.
you had a great weekend. Please post your question in the comment section. Uh, but before I take Rag's question or our other viewers' question, Steve, I would like to come to you and ask you that, I mean, what can our viewers expect from today's show? Or what would you like to tell them?
Excuse me. Well, Rajni, the Trump administration, excuse me, is implementing more extreme vetting of any foreign nationals coming into the United States. As you see all around the world, there's been a rightward shift against immigration, nation after nation, and the United States is no different. Um, so even those who have immigrant legal status and want to come back into the United States, they're going to face more extreme vetting. They're going to face questions. They're going to be put into secondary. And what we've seen happening is that Indian national green card holders, especially more elderly green card holders from India, are coming back into the United States after spending, say, 5 months abroad in India with family. And then they're coming back to their homes in the United States, and they're being forced to sign I-407 forms, which basically relinquishes your green card. So it's important to know your rights and know exactly what you're signing, and also understand the implications of whatever you sign. These people did not have to sign it, but it's very intimidating when you come into a nation and you have somebody with a badge telling you, oh, well, we don't think you're really a resident of the United States, so here, sign this and then give up your green card. It's easy to lose track of your rights. So it's important to know your rights, and it's important not to panic and sign anything when you're entering. Um, if you have access to an attorney, you can call the attorney from the airport. Taking calls from people in the airports and ask, does this sound right to you? Should I sign this? And of course, the attorney's going to say, no, it doesn't sound right, and don't sign anything. But they can kind of wear you down. They can put you in secondary for hours. They could detain you for days. And that's happened, not just to Indian nationals, but even Canadians. There was a Canadian movie actress trying to come back to her home in Los Angeles. And she was detained for, I think, 2 or 3 days as they interrogated her and about her status and her legal immigration status. So this seems to be the new modus operandi, if you will, of U.S. CBP, and they're going to keep doing it. I mean, as long as people keep submitting, they're going to keep doing it. So first thing is know your rights. The second thing is be prepared to defend those rights, and don't be intimidated. Any type of activity by any government that is designed to strip you of your rights only succeeds more easily if you submit to that. So, right now, immigration attorneys are, we're currently advising green card and H-1B visa holders to avoid any non-essential international travel due to these heightened risks of delays and denials and detention. H-1B holders, a lot of folks watching who either know somebody with an H-1B visa or have one themselves, but they face like tightened eligibility for interview waivers, the drop box. So we're going to see more requirements of in-person appointments for visas expired beyond 12 months. Consular officers could deny applications even with USCIS approval. So you go get your H-1B approved by USCIS Service Center, and then you try to get your visa, and we're seeing that doesn't always work out. They're still getting denied at the State Department, at the consulate. So that'll strand you. That strands workers abroad during prolonged administrative processing. Green card holders and visa entrants reporting more frequent secondary inspections, like extended questioning and detention, even for minor past offenses like marijuana possession. It's important to remember marijuana still Schedule I drug at the federal level, even though some U.S. states are permitting recreational use. The federal government is not. So all travelers are advised to carry extensive documentation, employment letters, proof of U.S. ties, and do not sign forms like that I-407 without contacting an immigration attorney. There's also an anticipated travel ban coming. So it's been leaked from the White House, a proposed 3-tier travel ban that's targeting 43 nations, and that could impose complete entry bans. That would be the red tier, or heightened vetting. That's the orange and yellow tiers. So while it's not yet active, uncertainty persists, particularly for nationals of countries like Afghanistan, Iran, and Venezuela. And as far as Indian green card holders, they face risk of residency abandonment abroad if they spend over 6 months without a re-entry permit. It's important to get that re-entry permit. So attorneys are cautioning against prolonged trips and emphasizing proof of U.S. ties. So that means having on you, tax returns, leases, mortgage payments to avoid re-entry challenges. You may be challenged, but at least with those documents, you should be able to re-enter the United States. But there's a lot of policy volatility right now with the Trump administration. They've issued numerous executive orders. Department of Homeland Security guidance has intensified enforcement, including expedited removals, and expanded administrative warrants. So political shifts in 2025 are reviving these restrictive policies, and that exacerbates delays and denials. Um, so at the U.S. airports, what does this mean? These recent trends and policy shifts of increased scrutiny. Well, enhanced vetting is the first thing. That's the first thing you'll notice. The Trump administration's January 2025 enhanced vetting executive order has intensified checks on social media activity, on your personal electronic devices, and also the travel history to see where else you've traveled around the world. What we're finding is that those who have criticized Donald Trump, the Trump administration, or Trump policies are having a much more difficult time of gaining reentry. In fact, some have just been flat out denied entry. So this is going to include prolonged detentions, secondary inspections, and challenges to your permanent residency intent for green card holders. So if you have an extended absence abroad, CBP is going to challenge whether you actually intend to reside in the United States, which is required, of course, of green card holders. And I mentioned that travel ban with the red, orange, and yellow tiers, that follows leaked internal memos, and it's perfectly in line with broader immigration restrictions. TPS designation terminations, which doesn't affect India directly, but there have been recent cancellations of temporary protected status, or TPS, for Venezuelan and Haitian nationals to eliminate reentry authorizations for those groups, which forced those foreign nationals to navigate stricter reentry protocols when they travel abroad. Administrative processing delays are on the rise. Visa holders are reporting increased delays due to consular officers returning cases to USCIS for re-adjudication. So you were approved at the USCIS, but now CBP is saying, no, we're going to send this back to USCIS for re-adjudication. So that's led to prolonged overseas stays for H-1B workers and others awaiting visa reapproval. And that's compounded by arbitrary secondary inspections at the airport. Also, this month, March and April, there's real ID enforcement and spring break surges because a lot of college kids are going abroad to spring break and then trying to get back in. So while there's not direct targeting of visa holders here, the May 2025 real ID deadline and heightened spring break travel volumes have increased overall airport congestion, which just exacerbates scrutiny during peak periods. So all of that, the delays that you get with the extreme vetting, the increased travel just makes those delays longer. And there's also a lot of technology-driven security upgrades at airports. There's AI-powered TSA checkpoints that's aimed to streamline screening, but their rollout coincides with broader security investments, such as biometric systems, CT scanners, facial recognition, which we know that CBP has been using for years now. So that's going to indirectly tighten oversight for certain traveler categories. The question was raised earlier prior to the show about folks with old criminal charges or minor criminal charges, even if they're a green card holder. Like, could that prevent entry into the United States? And a lawful permanent resident or green card holder with an old or criminal charge can face complications when attempting to re-enter the United States, but outright denial of re-entry is not automatic. So here are the considerations in that. Green card holders cannot be denied re-entry solely based on having a criminal record. Instead, they may be referred to an immigration hearing to determine whether they are deportable under U.S. immigration law. And while it's not a flat-out denial, that is not a comfortable process. Certain crimes, such as aggravated felonies, crimes involving moral turpitude, drug offenses, or violent crimes, will make a green card holder deportable or inadmissible. Now, if the person is deemed inadmissible for crimes committed abroad or serious offenses, the individual may be detained and subject to removal proceedings. Now, minor charges or old offenses may not automatically trigger removal proceedings unless they fall under specific categories outlined in immigration law. So, again, this is why it's so important to understand your rights and doing so in consultation with an immigration attorney. So, for instance, crimes of moral turpitude is within 5 years of obtaining residency, that's going to be a problem. But there are exceptions, like the petty offense exception or the youthful offender exception that may apply in cases involving minor crimes committed long ago or as juveniles. Now, crime's not the only factor that would affect reentry into the United States. For instance, the length of time you spend outside the United States is a factor. Staying abroad for more than 180 days or traveling while in removal proceedings can complicate reentry. Then there's abandonment of residency, whether you actually intended to abandon or not. It can be inferred from other actions. Actions such as staying outside the U.S. for extended periods without a valid reentry permit that can lead to claims that you abandoned your permanent resident status. And you can lose your green card. Now, green card holders facing inadmissibility may apply for waivers on the Form I-192 under certain circumstances to regain their eligibility for reentry. But legal representation is crucial for navigating these situations and protecting your immigration status. So, while an old or minor criminal charge does not automatically result in denial of reentry, it can lead to legal scrutiny and potential removal proceedings depending on the nature of the offense and other circumstances surrounding the case. So, how long can a green card holder stay outside the U.S. without risking their residency status? What counts as abandoning residency? So, green card holders must be cautious about the length and the nature of their trips outside the United States to avoid jeopardizing their residency status. Now, there are time limits for staying outside the U.S. For trips under 6 months, generally, absence of less than 6 months are considered temporary and do not affect a green card holder's residency status. However, we've seen that CBP has shoved the I-407 under the nose of Indian green card holders, especially the elderly, and says, sign this. Even though you weren't out for 6 months, we don't think you have intent to stay as a resident in the United States, so they'll sign a paper out of panic and lose their green card. So know your rights. That's always the first step. But frequent and repeated trips may still raise questions about your intent to maintain U.S. residency. So you can't just go out for 3 months, come back in for a week, leave for 4 months. That's going to raise questions. Now, trips between 6 months and 1 year long, okay, that may trigger scrutiny. It's going to trigger scrutiny from CBP. Those officers are going to be looking at that upon your reentry. Now, green card holders may need to prove their intent to maintain U.S. residency by showing strong ties like employment in the United States, property ownership in the United States, or family connections in the United States. I recommend all three if you can do that. So if a green card holder stays outside of the U.S. for more than 1 year without obtaining a reentry permit beforehand, they are generally going to be considered to have abandoned their residency status. A reentry permit allows absences of up to 2 years, but that must be applied for before leaving the United States. So abandonment occurs when a green card holder demonstrates an intent to no longer reside permanently in the United States. And this is determined by factors such as length of absence. Longer absences increase the risk of being deemed to have abandoned residency, especially if they exceed 1 year without proper documentation. The purpose of travel: trips that appear to establish permanent ties in another country, such as foreign employment, foreign property ownership, that may signal abandonment. Intent to return. Now, green card holders must show consistent intent to return to the United States, supported by actions like maintaining a home in the U.S., filing taxes in the U.S., keeping bank accounts in the U.S., and holding a valid driver's license in the U.S. Those are all important indicia of intent to return, to hold on to your green card. and maintain continued ties to the U.S. Evidence such as family connections, employment, community involvement in the United States, that all helps to demonstrate an intent to maintain residency. Now, if you're deemed to have abandoned your green card, there are consequences. So, if CBP officers suspect abandonment upon reentry, they could revoke your green card and refer you to immigration court for removal proceedings. Additionally, abandonment disqualifies individuals from fulfilling naturalization requirements for U.S. citizenship. So, tips for protecting your green card status: limit absences from the U.S. to under 6 months whenever possible. Apply for a reentry permit if you're planning extended travel exceeding 1 year. Maintain strong ties to the U.S., such as owning property, filing taxes, keeping a valid mailing address in the United States, and then keep documentation on you, such as your proof of employment in the U.S. or family ties in the U.S. Keep that on you and be ready for reentry screening. So, by adhering to these guidelines and demonstrating clear intent to live permanently in the United States, green card holders can minimize risks of losing their residency status during international travel. So, say that you have your H-1B approval from the USCIS. How could you be denied re-entry or stuck abroad during visa stamping? Well, here are the common reasons. One is insufficient documentation. So, if you're missing essential documents, such as employment verification letters or pay stubs from your U.S. job, U.S. tax records, or financial statements from employers, that's a frequent reason for rejection. Also, inadequate proof of the employer-employee relationship, especially if you work at a third-party work site, that can lead to denial. So make sure you have those pay stubs from your U.S. employer. Um, in an employer-employee relationship issue, like immigration authorities, they will always scrutinize whether the petitioner, the employer, has control over your work conditions, including pay, duties, and supervision. So this is critical for roles involving third-party work sites. That's where things can get tricky. So make sure, hold on to those pay stubs. Now, specialty occupation requirement. You think, well, why would CBP or Department of State worry about specialty occupation? Isn't that just the USCIS matter? No, it's not. They're also going to be looking at whether the job meets criteria as a specialty occupation requiring a bachelor's degree or higher. And if the role does not clearly align with these standards, U.S. consular officers may reject the application. They'll check prevailing wage compliance. So, you need to have the documentation on you showing that your employer has making an offered wage that meets or exceeds the prevailing wage for similar roles in the same geographic area. Now, we always provide our clients with a page from the Department of Labor website showing what the prevailing wage is for that job in that area. So it's important to have that along with your pay stubs because wage discrepancies, if you're being paid less, that can result in rejection. Now, many applicants encounter delays due to security checks or background reviews during administrative processing. Administrative processing, that can result in delays for 4 to 6 months or longer. With the Trump administration, we only expect administrative processing delays to grow. Another reason why you may be denied entry, even though you have an approved H-1B petition, are prior visa violations, such as overstays or unauthorized employment. That can make your application inadmissible to the United States, which would lead to a denial during or reentry. And of course, with the Trump administration, they invoke a lot of policy changes quickly. So, we've seen stricter immigration controls and extreme vetting tactics that have increased scrutiny on H-1B visa holders at consulates and ports of entry. So be aware that your social media activity and employment changes are sometimes flagged during AI-driven vetting systems. They have systems that will review your social media and can report to the officer any criticisms that you've made of the United States or President Trump or President Trump's cabinet. So during reentry, U.S. CBP officers may deny admission if there are discrepancies are found in previously filed petitions regarding your pay structure, your job duties, or employer details. They have all of this at the ready. Okay, all of your applications are in a database. Now, some travelers face expedited removal or visa cancellations due to investigations into certain employers or suspected non-compliance with immigration laws. So even if you're fine, if your employer is being investigated, that can lead to problems for you. Um, and there are prolonged processing times. So visa renewals often require interviews if expired for over a year, which can lead to delays that leave workers stranded abroad. So for the H-1B holders out there, or if you know H-1B holders, to mitigate risks, just avoid international travel unless it's absolutely necessary. Ensure that all of your documentation is complete and accurate before attending a visa interview. Again, consult an immigration attorney. I'm not just saying this to drum up business, because it's the immigration laws are sometimes self-contradictory, often vague and opaque. It helps immensely to have a professional who's been through these regulations before to address potential issues proactively. And if unavoidable travel occurs, set up contingency plans such as remote work arrangements with your employer in case of delays. Now, what is administrative processing? Well, administrative processing refers to a stage in the U.S. visa application process where additional review or security checks are required before a visa can be issued. Now, this step, which is often triggered after the visa interview, is used when consular officers need more information or clearance from other U.S. government agencies. Okay, not just the consulate, but other U.S. government agencies to determine your eligibility. It is commonly associated with a 221G notice, which indicates that the visa cannot be approved immediately and requires further review. Now, why does administrative processing happen? Well, several factors can lead to administrative processing, including security concerns, right? The applications may undergo additional scrutiny if the applicant's background raises potential security concerns, such as research in sensitive fields like artificial intelligence or biotechnology, or ties to countries perceived as adversarial by the United States. And that list of countries perceived as adversarial is changing rapidly, right? It used to be Russia. Well, now Russia's kind of considered an ally. Europe used to be an ally to the U.S., but now the U.S. is rather antagonistic to Europe. So it's important to stay abreast of all of the policy changes of foreign policy that the Trump administration is having. What else? Why else does it happen? Well, nationality or travel history. So applicants from certain countries like Iran, China, Pakistan, or people who have extensive travel to those regions. So even if you're an Indian national, but you have extensive travel to Iran, China, or Pakistan, or to regions with strained U.S. relations, you may be put in administrative processing. Incomplete documentation is another reason for administrative processing. So missing or insufficient documents like medical exams or biographical details, that can trigger administrative processing. Past military service with a military of a nation other than the United States can trigger administrative processing. And other background checks, factors like prior visa overstays, criminal records, even gender in some cases can prompt further review, especially people who wrote somewhere on social media or some application form that they have a gender other than male and female. That may trigger scrutiny because the Trump administration issued an executive order saying that the federal government will only recognize the at-birth gender of a person. So why are so many people getting stuck abroad? Well, the increasing number of individuals stuck abroad due to administrative processing can be attributed to several reasons. And number one are the policy changes and heightened scrutiny of the Trump administration. So recent U.S. immigration policies have emphasized the extreme vetting, which results in more cases being flagged for administrative processing. So, for example, an executive order issued this year mandated maximum screening for all immigrants, maximum screening. Also, increased demand in backlogs. Visa appointment wait times are at record highs due to post-pandemic travel surges and reduced staffing at consulates. This has exacerbated delays in both interviews and administrative processing. And while the Department of State in the United States aims to complete administrative processing within 60 days, these cases often take months or even longer, depending on the complexity of the review and the interagency coordination of information exchange between Department of Homeland Security and Department of State. So while many H-1B and other work visa holders traveling abroad for visa stamping are disproportionately affected. So for instance, tech professionals and researchers in sensitive STEM fields often face prolonged delays due to technology-related security clearance. And also, there are changes to visa interview waiver policies that now require more applicants than before to attend in-person interviews, which increases the likelihood of being subjected to administrative processing. So the consequences for applicants are being stuck abroad due to administrative processing, which can have severe personal and professional consequences because that means they can't return to work or to school in the United States. That also puts a financial strain from extended stays abroad and disruption of family life and critical responsibilities. So what can be done? Well, while applicants cannot directly expedite administrative processing, they can take steps to minimize delays. The first and most important is submit all of the required documentation promptly if requested by the consulate. So if they put you in administrative processing, quite often they'll give you a piece of paper saying, we need information about boop, 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 boop. Get those documents to them as fast as you can. Contact the consulate after a reasonable period of time, such as 60 days for updates. Seek legal assistance or even congressional intervention for prolonged delays. Usually your employer's representative to the U.S. House of Representatives or to the U.S. Senate will be happy to intervene. But also plan your international travel very carefully and keep those potential delays in mind. Now, how are long visa wait times and consular delays in countries like India affecting H-1B professionals and their families? Well, long visa wait times and consular delays in India are having a profound effect on H-1B professionals and their families. It's just disrupting careers, disrupting family dynamics, and overall stability. So when you talk about career disruption, India H-1B workers face significant delays in transitioning to green cards due to country-specific quotas and retrogression policies. And in some cases, the wait time for green cards are well over 10 years, which leaves professionals in a prolonged period of uncertainty. And visa-related delays have led to job offer withdrawals and layoffs as employers grow reluctant to sponsor visas due to administrative burdens and unpredictable timelines. It also increases the cost, right? The extended processing times force applicants to spend more on legal assistance and alternative visa options, such as the EB-5 investor visa, which are often unaffordable for many people. It's heightened immigration anxiety, right? Stricter policies under the Trump administration have heightened fears of visa denials or prolonged administrative processing, leaving workers stranded abroad for months. And the uncertainty over future policy changes adds stress to professionals who rely on seamless visa transitions to maintain their employment status. Now, I know this is an immigration and jobs talk show, but we can't ignore the impact of these delays on families. Now, first of all, there's family separation, right? Long delays in visa stamping and green card processing mean that families are often separated for extended periods. For instance, workers traveling abroad may face months-long delays before returning to the U.S. Family reunifications are indefinitely postponed, which further strains relationships. And families face challenges in planning their lives due to visa unpredictability. Elderly parents visiting from India are subjected to increased scrutiny at U.S. borders, sometimes being pressured to relinquish their green cards, as I described earlier. Now, the delays deter smaller companies from sponsoring Indian workers, potentially affecting the U.S.'s ability to retain skilled talent in STEM fields, where Indians form a significant portion of the workforce. Indian professionals contribute significantly to the U.S. economy, but visa bottlenecks hinder their ability to fully integrate and innovate within their roles. So some individuals resort to risky workarounds, such as overstaying visas or accepting exploitative contracts due to the slow and unpredictable immigration system. And we discourage doing any of those desperate measures. So Indian travelers face wait times now exceeding 400 days for B1, B2 visas at major consulates in India, which pushed some applicants to seek faster appointments at international consulates, which is a costly and logistically complex alternative. Now, these delays underscore systemic inefficiencies in U.S. immigration policies that disproportionately impact Indian nationals because of the vast numbers of Indian nationals seeking immigration to the United States. And addressing these challenges is critical for maintaining bilateral ties between India and the U.S., supporting skilled migration, and ensuring family unity for the affected workers. Now, of course, we're not just talking about H-1Bs, we're also talking about the dependents, H-4 visa holders, right? So H-1B and H-4 visa holders can face potential reentry issues if they travel internationally while their visa renewal or extension is pending. So here are the key considerations. For H-1B visa holders, you can travel internationally while your H-1B extension petition is pending, provided you have a valid H-1B visa stamp and a prior I-797 approval notice that has not yet expired. So if your extension is approved while you are abroad, you will need the new I-797 approval notice to re-enter the U.S. So if you re-enter using the old approval notice, your admission will only be valid until the expiration date of the old petition. So you may need to leave and re-enter again with the updated documents to correct your I-94 record. Now, if the petition involves a change of status from another visa type to H-1B, traveling during the pending process may result in abandonment of the change of status request. However, this does not apply to extensions of status. So if your current H-1B status has expired and you're relying on the 240-day automatic work authorization extension, you cannot travel internationally until your new petition is approved. So, and you come back to the port of entry, ensure that your I-94 record upon re-entry matches the validity of your most recent approval notice. And if there's a discrepancy, it may require corrective action, such as traveling outside and re-entering again. Now, for H-4 visa holders, it's very similar to H-1B visa holders, but H-4 dependents can travel while their extension is pending if they have a valid visa stamp and prior approval notice. However, if their extension is approved while abroad, they will need the updated approval notice for re-entry. And if an H-4 EAD renewal is also pending, traveling abroad does not generally affect the renewal process. However, re-entry issues could indirectly impact work authorization if there are delays in obtaining updated documents. So the general recommendations are always travel with a valid passport, valid for at least 6 months beyond your intended stay, a visa stamp, prior I-797 approval notice, and employment verification documents. Keep track of whether your extension petition is approved while abroad so that necessary documents can be sent to you for reentry. And it's also good, given the complexity of immigration rules, to consult with an immigration attorney before making international travel plans during a pending visa renewal or extension. So while travel during a pendency renewal or extension is possible under certain conditions, It carries risks such as truncated admission periods or needing additional steps to align I-94 records with new approvals. So careful planning and consultation with legal experts are advised to avoid those complications. I'm often asked, what documents should green card holders and visa holders carry on them to avoid problems at the border or during secondary inspection? So green card holders and visa holders should carry specific documents to ensure a smooth re-entry into the United States and avoid complications during inspections at ports of entry. So what you need for green card holders, you need that valid green card, Form I-1551. Always carry your unexpired green card as proof of your permanent resident status. Your passport, now, although not always required, having a valid passport is advisable, especially for international travel. Your re-entry permit, if applicable. If you have been outside the U.S. for more than a year, you must have a valid re-entry permit to avoid being considered as having abandoned your residency. And proof of U.S. ties, probably more important now than ever. To demonstrate that you have not abandoned your residency, carry evidence such as your recent U.S. tax returns, proof of property ownership or a lease agreement in the U.S., employment verification or proof of job offers in the U.S., and family ties, such as proof of children attending school in the United States. And be prepared to explain extended absences from the U.S., especially if they exceed 6 months, as this may raise questions about abandonment of residency. Now, for visa holders, ensure your passport is valid for at least 6 months beyond your intended stay in the U.S. Carry your unexpired visa that matches the purpose of your visit, whether it's work, study, or tourism. Print and carry the most recent I-94 record from the CBP website to confirm your last entry and permitted stay duration. They will need some visa-specific documents, right? For work visa holders like your H-1Bs and L-1s, bring your I-797 approval notice and your employment verification letter, pay stubs, and other supporting documents like the Form I-129S that has the annotation of approval for L-1 visa holders. For students in F-1 and J-1 visa status, carry your SEVIS Form I-20, which is signed by the designated school official, or your DS 2019 proof of SEVIS fee payment, and evidence of enrollment such as a class schedule or letter from your school. And additional supporting documents, tax returns, bank statements to demonstrate your financial stability and ties to the U.S., and also hiring letters or proof of funds for scholars and employees. But general tips for all travelers: organize your documents, keep physical copies in a secure folder with digital backups and cloud storage. Okay, cloud's accessible everywhere. Be prepared for secondary inspection. So if you're directed to secondary inspection, remain calm, do not panic, and answer questions truthfully. The officers may ask about your travel purposes, your ties to the U.S., or extended stays abroad. And do not sign forms without legal advice. For example, never sign Form I-407, which is abandonment of lawful permanent residence, without consulting an attorney if you're a green card holder. So by carrying these documents and maintaining strong ties to the U.S., you can minimize delays and complications during border inspections. So what are the risks of traveling while on an adjustment of status or with advanced parole, especially with renewal delays? Well, that carries several risks, okay, especially in light of the renewal delays and the evolving Trump immigration policies. So here are some of the key risks and considerations for you. The risks of traveling while on advanced parole is reentry is not guaranteed, okay? Holding a valid advanced parole document does not guarantee reentry into the United States. The U.S. Customs and Border Protection officials have discretion to deny admission even if all documentation is in order. So travelers may face heightened scrutiny upon return, especially if there are changes in their circumstances or changes in immigration policy during your absence. So for abandonment of AOS application, if you leave the U.S. without a valid advanced parole document or during its renewal process, can result in the abandonment of your AOS application, which leads to denial and requiring you to restart the green card process from abroad. So current processing times for advanced parole renewals can range from 8 to 14 months, which creates significant delays. If your advanced parole expires while you are abroad, you may be unable to return until a new document is issued. And under recent policies, individuals who have been in the U.S. for less than 2 years or who face scrutiny at the border may be subject to expedited removal proceedings, even with advanced parole. Now, immigration programs relying on discretionary parole authority, such as DACA or TPS, they face increased vulnerability due to policy changes or legal challenges. And this could impact travelers using advanced parole under those programs. Now, some travelers with valid advanced parole documents have been denied reentry at U.S. borders due to evolving enforcement priorities, leaving them stranded and potentially jeopardizing their immigration status. So, if the travel is not urgent, it is safer to remain in the U.S., especially given the unpredictability surrounding advanced parole reentry. And before traveling, you should seek legal advice to assess risks based on your specific case and recent Trump policy updates. So stay informed about USCIS and CBP updates. It could affect reentry procedures or advanced parole validity. And your immigration attorney will know these things. So have contingency plans ready, including access to legal assistance and accommodations outside the U.S. in case CBP denies your return. And if AP renewal, advanced parole renewal delays conflict with urgent travel needs, consider filing for emergency advanced parole or pursuing litigation options like a mandamus lawsuit to compel USCIS action. So again, traveling while on AOS with advanced parole involves significant risks due to policy uncertainties, heightened scrutiny at borders, and renewal delays. So it's crucial to carefully evaluate the necessity of travel and take proactive measures to minimize potential disruptions to your immigration status. Consulting an experienced immigration attorney, highly recommended before making any travel plans. Now, if a green card holder has stayed abroad longer due to a family emergency, how can they prove they didn't abandon their U.S. residence? So there are several steps that can prove that. First, you have to document the reason for the extended absence. So you provide evidence showing that the extended stay was due to unforeseen circumstances beyond your control, such as medical documentation for a family emergency or other supporting documents like that that justify the delay. Also, they need to demonstrate ongoing connections to the United States, such as ownership or rental of property in the U.S., active employment or business ties in the U.S., family connections like a spouse or children residing in the U.S., show that you filed U.S. income tax returns regularly, and maintaining U.S.-based financial accounts and insurance policies. All show that you're maintaining strong ties to the United States. You also have to prepare evidence of temporary intent for your travel. You have to show that your stay abroad was temporary and that you had a continuous intention to return to the United States, such as keeping personal belongings in your U.S. residence, maintaining a valid U.S. driver's license, and then proof of return travel plans like flight tickets. You show them and say, here, I bought a flight back to the United States. And if you were abroad for over 1 year without a reentry permit, you should apply for an SB1 visa at a U.S. consulate before returning. This visa requires proof that your extended absence was due to circumstances beyond your control and that you intended to maintain permanent residency. You also need to be prepared to answer questions from Customs and Border Protection officers about your absence when you get to the port of entry, such as why were you abroad, what ties you maintain with the United States, and where your primary residence was located. Avoid actions that indicate abandonment, okay? Like declaring yourself a non-resident alien on a tax return. Okay, that indicates abandonment. Voting in foreign elections indicates abandonment. Or selling property or terminating employment in the United States also indicate abandonment. So if possible, green card holders should apply for a reentry permit before leaving the United States, especially if they anticipate being abroad for more than 1 year. This document signals intent to remain and maintain your residency, but it must be applied for while you are in the United States. And consult an immigration attorney. That's going to be hugely beneficial to you, especially if CBP challenges your residency status or if you need help in applying for an SB1 visa. So, by providing clear evidence of ties to the United States and documenting the temporary nature of your stay abroad, green card holders can effectively counter claims of abandonment upon reentry. Now, we also have the question of, can H-1B holders travel during the 60-day grace period after job loss without impacting future immigration filings? And the answer is no. H-1B visa holders cannot travel outside the United States during the 60-day grace period following a job loss without negatively impacting their immigration status and future filings. So, departing the U.S. during this time effectively ends the grace period, as its purpose is to allow the individual to remain in the country, in the United States, to either secure new employment, apply for a change of status, or prepare for departure. Reentry into the U.S. during this period is not permitted unless a new H-1B petition or other valid visa has been approved. Now, additionally, leaving the U.S. during the grace period can complement future immigration processes, as it may result in being considered out of status if no other valid visa is obtained before departure. Now, this could affect your eligibility for future visa applications or adjustments of status. So, H-1B holders are advised to remain in the U.S. during the grace period and consult with an immigration attorney to explore your options. Now, got another question of what are the most common mistakes people make when going for H-1B or H-4 visa stamping abroad? Well, when you're seeking H-1B or H-4 visa stamping abroad, applicants often face challenges that can lead to delays or denials. Now, here are the most common mistakes and pitfalls to avoid. First of all, documentation. Incomplete or incorrect DS-160 form. Okay, errors or omissions in the DS-160 form can result in visa processing delays or denials. So the applicants must ensure all information is accurate and consistent with supporting documentation. Also, missing essential documents, such as the I-797 approval notice, pay stubs, marriage certificates for H-4 applicants, or evidence of qualifications can lead to complications. And after re-entering the U.S., it is crucial to verify the I-94 expiration date and visa category online to ensure accuracy. You see a lot of these errors. CBPs sometimes are just zipping people through and they make errors on the I-94. Those errors in this document can cause status issues. The second pitfall are employer and employment issues. So short gaps between jobs, but within the legal grace period, are typically acceptable, but failing to document these properly on the DS-160 form could raise concerns during stamping. Employers may incorrectly classify job roles when filing H-1B petitions, which can lead to visa denial if the position is not deemed a specialty occupation. And employers, make sure, talk to your employees about this, they must ensure an approved labor condition application, the LCA, is obtained and complies with wage requirements, because failure to do so can result in petition denial. Now, some common mistakes for dependent visa H-4 holders. Dependents often fall out of status if their H-4 extension application is not filed alongside the principal H-1B extension. So for newly married couples, scheduling an H-4 interview too close to the wedding date may raise concerns about the legitimacy of the marriage. Dependents traveling abroad with pending extensions must ensure that they have a valid visa stamp for re-entry. Otherwise, they may need to reapply for their extension upon return to the United States. There are also some consular-specific issues, like some consulates, such as those in India, may have higher risks of administrative delays as your 221Gs. Applicants often prefer locations like Canada for faster processing if you can get a third country national appointment. While consular officers generally do not re-adjudicate approved petitions, discrepancies between interview answers and petition details can lead to rejection. They do have access to your petitions. A couple of other common mistakes: ignoring your passport expiration date. Okay? If the passport expires before the approved petition's end date, CBP officers may issue an I-94 with the shorter validity period upon reentry. So they'll tie it to the passport expiration, not the approved petition's end date. And also aging out for H-4 dependents. Children turning 21 lose eligibility for H-4 status and must apply for a change of status, such as F1, before aging out. So by carefully preparing documentation, verifying your information, addressing potential red flags proactively, you can significantly reduce risks during the visa stamping process. Again, consult with an immigration attorney for advisable. It's more than advisable for complex cases or uncertainties. I'd say it's this day and age is necessary. Another question we received is, what's the risk of being referred to secondary inspection, and how should travelers prepare for questioning by CBP officers? Well, let's address the risks first. Why are you put in secondary? Well, missing or incomplete documents such as visas, passports, or travel-related paperwork that can prompt secondary inspection. Your travel history, right? Past overstays, criminal convictions, or inconsistencies in travel records may trigger additional scrutiny. Nationality or affiliations. So travelers from countries subject to U.S. sanctions or restrictions, or those affiliated with sensitive entities or STEM fields, may face heightened scrutiny. Electronic devices. CBP officers may inspect electronic devices for suspicious content, which could lead to further questioning. So again, do not criticize President Trump. Make sure any behavior that may be illegal, such as drug use, marijuana, smoking, something like that, make sure that is not on any of your electronic devices. And then there's also random selection. I mean, secondary inspection can also occur randomly as part of a routine check. So how do you prepare for questions by CBP officers before traveling? Well, ensure all of your required documents are complete and accessible. Your passport, your visa, return tickets, your accommodation details. Double check your visa application and all supporting materials for accuracy and consistency. And limit the number of devices that you carry, electronic devices. Limit the number of those devices you carry and avoid applications or files that could be misinterpreted during inspections. And during question, maintain composure, avoid confrontations with officers, stay calm and polite, and provide direct responses to questions about your travel purpose, your duration of stay, your accommodation, and financial means. And avoid providing unnecessary details that could complicate the process. And if you're asked to sign documents, request clarification, or even better, legal counsel before proceeding. And while non-citizens do not have the right to legal representation during inspections, you can ask to contact an attorney if needed. So follow the officer instructions, provide the requested information calmly, and then once you're released, write down the details about the inspection process for future reference. And that will also help your attorney as well. So by understanding potential risks and preparing thoroughly, travelers can navigate CBP inspections more confidently while minimizing delays or complications.
Wow. Steve, I think that was a masterclass. You covered so much in just one go. I'm sure all of our viewers are already feeling a little more at ease after listening to you. So that was like a masterclass. So, I was completely lost in this
That's
conversation.
right.
I had so many questions coming in my mind while you were talking, but then, when you were moving to the second topic, you were answering that question as
Good.
well. So, I think that was a brilliant, brilliant
Okay,
masterclass.
great.
And I think let's just build a little on that and go a little deeper by taking maybe a viewer's question, which people have posted in the comment section.
Mhm.
So, yeah, let me quickly take them. So, first question that was asked was from Bhargav Gupta. So, Bhargav says, my mom is critically ill overseas and I urgently need to travel. Will CBP question me when I return since I've been outside the US recently too? And before you answer that question, Steve, I would like to tell our viewers, guys, that was a detailed and insightful answer. Steve covered basically all of your queries, all of your concerns regarding the traveling issues that is going on. So make sure to hit the to share this video with someone who you think can benefit from all this information. And yes, do share this episode with them, and also make sure to like this video and subscribe to Immigration Talk Show. And yes, Steve, please go ahead.
Yeah. So,
What would you
first of
tell
all, I'm very
Bhargav?
sorry to hear about your mother, Bhargav. The key is to document the reason for your travel again. So just because you traveled recently, since then your mother fell ill, and you need to get back. So what you need are uh, a letter from her doctor or hospital. If she's admitted to a hospital, maybe the admission record showing her admission to the hospital. And what you should do also, um, I don't know what status you're in. Did she say what status she was in? Um, don't
Um, I
recall.
don't
Yeah.
think so.
So
Please.
you might want to get if you know if you're in a status of say H-1B or L-1, where you have dual intent, both immigrant and non-immigrant intent, you should be fine to travel as long as you're in valid status. If you are not, you should get an emergency advance parole. Document the reason why you need to go, and you're going to have to document with some medical records, like a letter from the doctor or hospital that discusses your mother's condition and the severity of her condition. Um, so you can expect questioning upon your return. But again, if you have your records documenting your mother's medical condition, her stay in the hospital, and also your ties to the U.S., your driver's license, your children's school records showing that they're going to school in the U.S., your employment in the U.S. with pay stubs, your home, either mortgage or lease payments, then you should be able to re-enter.
Okay. So, Bhargav, all the best to you. I hope you're able to re-enter without going through any problem. So, yes, if you do face any issue or anything, make sure to get in touch with your attorney. And if you're looking for one, so you can also give a call to
Yeah.
Steve. So, his details are already scrolling below, but I would again like to read them for you so that you can note it down. You can give him a call on the number 202-537-4830. I would like to repeat it again, 202-537-4830. You can also email him. His email is steveh at trowrahal.com. Steve H at trowrahal.com. And you can also visit his website, which is www.trowrahal.com. So, yes, make sure to get in touch with Steve. And I wish you, okay, he says, I am on H-1B.
I think
So,
uh, I think Sakshi has a question about
yeah, Sakshi has a
the
question, but
amendment.
do you have any other advice for Bhargav since he's
Oh,
saying
she's
I'm
on
on
H-1B.
H-1B,
Okay, so
Steve?
she should be able to travel without problem as long as she's in
Okay.
valid H-1B status. And also make sure, Bhargav, that your visa is still valid and that you can re-enter on that visa without having to get another visa. Of course, it's hard to say given your mother's condition, unfortunately, how long your stay in India would be. But make sure that your visa is valid, that you have a valid visa, and that your authorization period is valid also. If that changes, then you'll have to reapply at the consulate before you can come back to the United States. But again, all the best to your family and your mother.
Yeah. All the best, Bhargav. Thank you so much for posting your question. If you have any follow-up, continue posting them in the comment section. Even if the show is over, we'll try to get an answer from Steve and we will try to reply back with an answer. So yes, if you have any more follow-ups, please continue posting them. Meanwhile, let me quickly take Shokat's question. So Shokat says, foreign travelers to the US are advised to review their online presence before applying for a visa or traveling. US authorities are increasingly scrutinizing public digital footprints and inconsistencies between online profiles and visa applications can lead to delays or denial. Is it same for everyone? People are already having visa and people applying for new visa. What would you like to tell Shaukat?
Well, generally, if I think they would prefer the people with existing visas, but yeah, renew visas again. If you've been a visa holder for less than 2 years, and there's something inconsistent about your information or records, and maybe you have things on your digital footprint, as you say, that CBP or maybe the Trump policies would say are unsavory, that they don't want, then you are at risk of the automatic removal or the so it's important to clear that online presence before you apply or you travel to the United States. It's really, we advise this kind of mildly before, but we advise everybody to review their online presence. Uh, so because everybody's going to be looking at it, the Department of State's looking at it, Customs and Border Protection are looking at it, USCIS is looking at it. They're scrutinizing these public digital footprints as part of their background checks. So this practice aims to verify identity, detect inconsistencies with your applications, and flag potential risks such as unauthorized work or misrepresentation. So, for instance, the social media checks, I mean, visa applicants are required to disclose their social media usernames for platforms they've used in the past 5 years, like Facebook, Instagram, LinkedIn, and Twitter, which I guess is now X. And the immigration officers will review public posts and photos, employment details, and other information to ensure consistency with the visa applications. And there are automated systems that flag content suggesting unauthorized work or security risks or discrepancies between a person's online profile and their official documents. And of course, the device inspection by CBP officers, they have the authority to inspect travelers' phones, laptops, all electronic devices at U.S. borders without a warrant. These inspections may include reviewing social media activity. So while not all travelers face such scrutiny, reports of detentions or denials based on digital content are all on the rise. And even if there's a minor discrepancy between an applicant's digital footprint and the visa documentation, that's going to lead to delays. It's going to lead to questioning, possibly even the denial of entry. And posts related to political views, recreational drug use, or unauthorized employment, those have all been cited as potential red flags that can lead to denial. So make sure that your online profile is aligned with the information provided in your visa application, like job titles and employment history. They will check LinkedIn to see if it matches up. And then remove or update any outdated or potentially problematic posts that could be misinterpreted by immigration officials. Restrict access to your personal social media accounts to limit visibility of any sensitive content while ensuring compliance with disclosure requirements. And delete accounts right before applying for a visa. That may raise suspicions about intent or transparency. It's better to scrub the accounts that's better than deleting the accounts. Just scrub, but don't delete. So it's heightened scrutiny is just a broader trend of integrating digital surveillance into immigration processes. We're seeing that these days for sure.
Okay. Shaukat, I hope you've got your answer. If you have, make sure to subscribe to Immigration Talk Show so that you can get the access to more such shows in the future, because we come up with more, immigration related shows every day. So yes, and also immigration related videos. So make sure you like, share, and subscribe to Immigration Talk Show. And thank you so much for that question. That was really an interesting one. And if you have, any other question, you can continue posting them in the follow-ups. And guys, you can also join us on call. You can dial this number 425-436-6335. You can put the access code, which is 9 88888. Okay, I would like to take Sakshi's question, but before I do that, I would like to take Rag's question. Steve, he says, what is your advice for cap exempt H-1B counselor interviews? What would you like to tell Rag?
Well, I think the important thing there is to make sure that your employer is cap exempt. So, nonprofit research institute or or an organization that does research associated with a higher education institution, some hospitals as well, as long as they're a research hospital. So you should make sure that you emphasize the research part of the organization for which you are working, because that's the first thing you want to know is is your employer really cap exempt? And because some people may try to circumvent the lottery, the H-1B cap lottery, by applying for a cap exempt H-1B. But again, be truthful. Make sure that what you're doing is for your work is in line with the mission and objectives of the cap exempt organization, which should include a research component. And then make sure that your work is also inclusive of a research component as well. So this is the main advice. Make sure that your wage level, what you're being paid, meets or exceeds the prevailing wage for your position in your geographic area. That there's like a for-profit and then a nonprofit wage scale. So make sure you're using the nonprofit one because those wages are lower. So make sure, again, job title and duties have research component that are the same as the mission of the organization for which you're going to work. Those are the keys. And then, of course, all of your own personal stuff that we've talked about, social media, electronic devices, criminal record, all that stuff. Make sure those are all clean as well. But otherwise, it should be fine.
Okay, so Rag, I hope you've got your answer. In case you have follow-ups, please continue posting them. And thank you so much for being a regular viewer and always being there, to watch our shows and to post, any question that comes to your mind. We really enjoy taking your questions and we really enjoy talking to you. I hope, someday you can join us on call and you maybe, have a conversation with us, maybe, by giving us a call on the number. So, yes, if you have any follow-up, please continue posting it. Meanwhile, let me take Sakshi's question. So, okay, I think, okay, we'll take that question later. So, Sakshi says, if my employer has filed an H-1B amendment and I need to travel abroad during this period, could it interfere with my status when I re-enter the US even if my H-1B was approved previously? What do you have to tell Sakshi?
Yes, there are challenges and risks for re-entering the United States, even in that situation. So if the amendment involves a change of status from another visa type to H-1B, then traveling abroad while the petition is pending may result in the USCIS considering the change of status request abandoned. So while the underlying H-1B petition may still be approved, you would need to apply for an H-1B visa at a U.S. consulate abroad to re-enter the U.S. Now, if your H-1B amendment does not involve a change of status and your original H-1B petition is still valid, you can re-enter using your existing H-1B visa stamp and approval notice. But complications may arise if there are discrepancies that exist between your current employment details and the amended petition. And there usually are discrepancies between your current employment details and your amended petition, which is the reason why you're filing the amended petition, right? So if the amendment is approved while you're abroad, then you must re-enter using the new approval notice. So if you attempt to re-enter using the old approval notice after the amendment's been approved, you might only be admitted until the expiration date of the old one, which will require further corrections or travel. So what you want to do to ensure smooth re-entry, carry that valid passport that's valid for at least 6 months beyond your stay, a valid H-1B visa stamp, the original approval notice for your current H-1B status, Also, an employment verification letter from your employer that confirms the job details will be very valuable, and typically 2 to 3 recent pay stubs. Now, if you're traveling to Canada or Mexico for less than 30 days, you may qualify for automatic visa revalidation to return with an expired visa stamp, provided there are other conditions that are met. CBP officers may subject H-1B travelers to additional scrutiny regarding their employment details, their salary, their job duties. So, if there are discrepancies or missing documentation, that could lead to refusal of admission or expedited removal. So, it's strongly advised to avoid international travel while an H-1B amendment is pending unless absolutely necessary. And if it can't be avoided, then you should consult with an immigration attorney to assess your risks, because that could have an unhappy result.
Yeah. Mhm. Okay, Sakshi, thank you so much again for your question. I hope you have got your answer. And yes, you can also please continue posting your follow-ups if you have any more. And even if the show is over, we'll try to, answer your question by connecting with Steve over an email, or maybe you directly can get in touch with Steve by emailing him on his email, which is steveh@trowrahal.com. And you can also give him a call on the number 202-537-4830. Yes, let me very quickly take this another question. Steve, this question was actually on one of our YouTube videos. So this viewer has asked, I already filed the DS-160 form before taking the appointment, and post to this, I got a date for this year. My appointment has a barcode of previous submitted DS-160. Now I wish to update the information provided in the previous DS-160 in my newest DS-160. So here in this case, can I say at the biometric that kindly scan the new DS-160 barcode?
Yeah, that's kind of an interesting situation that doesn't come up enough or frequently. Um, so yeah, you can always make the request. Generally, we've seen some instances where folks did not complete the DS-160 in a timely fashion, and the DS-160 kind of disappears. But in this situation, where you have an old DS-160 and then you have a new DS-160, but you want to use the barcode from the new DS-160, I mean, you can ask that at your biometrics appointment, but there's some things you need to keep in mind. Bring both the old DS-160 confirmation page that's associated with your appointment and then the new DS-160 confirmation page. Okay, this is essential because the old DS-160 barcode is linked to your appointment, and the new one reflects the updated information. So they may not, if you only bring the new DS-160 barcode, then they may say, well, you don't have an appointment here. A lot of folks, everything is very rote, so they don't have a lot of flexibility and allowing people to have appointments without the right barcode. So bring both of your barcodes. And then once you're at the biometric center, notify the staff or the coordinator that you've submitted a new DS-160 form, and then request them to update your application with the new barcode. And they can scan the new DS-160 barcode and attach it to your application. So you've probably scheduled your appointment after November 15th, 2023, because there was a policy change on that date. But it would be mandatory to bring both confirmation pages, old and new, because again, without the old DS-160 confirmation page, your appointment could be canceled and then you'd have to reschedule. So ideally, updates should be made at least 3 days before your appointment by updating your profile online. But if this isn't possible, then informing staff at biometrics is a valid alternative.
Okay. All right. Thank you so much, Steve, for that great advice. I hope that helps. And make sure to follow Steve's advice. And yes, I think you'll be able to, clear that interview of yours. Okay. So, Steve, also, Rag is actually back, and he says, Rag, is a compelling circumstances H4 EAD possible without an I-140 filed?
Yeah, so to qualify for compelling circumstances EAD, employment authorization document, as an H4 dependent, the principal H-1B visa holder must have an approved I-140 petition. So, the principal applicant, the H-1B holder, must be the primary beneficiary of an approved I-140 in EB1, EB2, or EB3 categories. And then the applicant, including the H-4 dependents, must be in valid E3, H-1B, H-1B1, O1, or L1 status or a grace period at the time of filing. And the principal's priority date must not be current under the visa bulletin's final action dates. And furthermore, the applicant must demonstrate compelling circumstances, such as serious illness, employer retaliation. Sometimes employers retaliate against workers who say or do something, or if you're facing significant harm. So the H-4 dependents cannot apply independently for a compelling circumstances EAD because their eligibility is contingent on the principal applicant meeting all of the requirements, including the approved I-140. So if the principal H-1B holder has not filed or obtained an I-140 approval, then no compelling circumstances EAD is available for the H-4 dependent. But there are some alternatives you should realize. If the principal H-1B holder does not have an approved I-140, H-4 dependents may explore other EAD pathways, such as the H-4 EAD based on an I-485 pending. Of course, you have to be eligible to file an I-485 first, but if you are, then if the principal's filed an I-485 adjustment application, which requires a current priority date, then the H-4 can apply for an EAD. And there are also H-4 EADs available under AC-21 provisions, which are applicable if the principal is porting employment or employment to the other under I-485 portability rules. So compelling circumstances EAD for H-4 dependents is not possible, except for those two exceptions that I mentioned, without an approved I-140 petition for the principal applicant.
Okay. All right. So Rag, I hope that answers your question. Thank you so much again for posting your follow-up. And Steve, I think that's it. I mean, do you have any last advice for the audiences?
My advice is, in these times, it's uncertain, that things can look bleak, especially in terms of what's happening politically in the United States. But remember, you do have rights. And rights are not readily taken away without, or not as readily taken away when those rights are challenged. And you have to challenge the authority with the rights that you have. So contact an immigration attorney. I don't really care who at this point. I recommend Trow Rahal because I know the people, the attorneys here are outstanding and experienced. But contact an attorney and learn your rights. But also, if you don't need to travel, if you're just traveling for pleasure, consider waiting a while. Okay. Unfortunately, that's the world in which we live. But know your rights and fight for your rights.
Absolutely. You don't want to turn your pleasure into pain, so make sure to avoid traveling, especially at this point in time. So, and if you want to get in touch with Steve, please give him a call on the number 202-537-4830. You can also email him. His email ID is steveh@trowrahal.com, and you can also visit his website, which is www.trowrahal.com. And Rag says, super episode. Thank you, Steve and Rajni and ITS team. Thank you so much, Rag, for being a continuous supporter, and thank you so much for always being there. And yes, looking forward to seeing you in another episode. And Steve, again, it was such an insightful and detailed episode, and I'm sure our viewers have gained a lot from today's episode. It was like a masterclass, so thank you again for doing this, and hoping to see you real soon with another topic.
Yes, absolutely. It's always a pleasure seeing you, Rajni, and working with your team here at the Immigration Talk Show.
Thank you so much, Steve. Thank you so much for those kind words. And yes, hoping to see you real soon. Until then, please take care. And yes, can't wait.
That's right. That's right. See you
All right,
next time.
guys.
Thanks,
Yes, please.
everybody.
Thank you. Thank you so much, Steve. And guys, that's it from our side. And yes, I am hoping to see you all very soon. But we have another show coming up at 4 o'clock, which is Daily Immigration Doors, a very interesting and insightful topic there too. So make sure that you are tuned in to that episode too. But for now, I'll have to take a leave. I'll be seeing you real soon with another show and with, yes, with another interesting insight from our expert attorneys. But for now, make sure that you like this video, share with someone who can benefit from this video, and also subscribe to Immigration Talk Show. I'm Rajni Bharara signing off for now.